the dish with one spoon territory. The dish with one spoon is a treaty between the Anishinaabe, Mississaugas, and Haudenosaunee that bound them to share the territory and protect the land. Subsequent indigenous nations and peoples, Europeans, and all newcomers have been invited into this treaty in the spirit of peace, friendship, and respect. Please join me in welcoming our esteemed speakers for today, Dr. Johan Guest and Mr. Mohit Arora. Johan Guest is a partner and parent agent in Faskin's Intellectual Property Department in Montreal. Johan achieved a PhD in electrical engineering from McGill in 2007 and is an active member of various professional organizations and affiliations. Working with clients ranging from startups to multinationals, Johan helps them to protect their innovations through patents and industrial designs. Johan's expertise includes electronics, optics, optoelectronics, telecommunications, software, and green technology. Mohit Arora is a patent technical advisor in Faskin's Intellectual Property Department. Mohit focuses on drafting and prosecuting patent applications for technology companies, protecting their innovations and contributing to technological progress. With a strong background in engineering and a passion for technology, he has carved a niche for himself and a patent professional specializing in drafting and prosecuting patent applications for tech companies. To date, Mohit has prepared more than 100 patent applications, with the majority of them being already granted. Over to you, Johan and Mohit.
Well, Mary Suzanne, thank you very much for the introduction. Thank you for giving us that opportunity. Thank you to Adnan too. So today we'll talk about patents, as the title says, when science and technology meet law. But before jumping, I'm trying to, sorry, we have a technical problem. Here, thank you. So before jumping into today's subject, patents, I just have one slide about intellectual property. So intellectual property refers to temporary commercial rights to creations of the mind recognized by law. Basically, anything that you may create with your intellect is intellectual property. And there are different rights in intellectual property. So maybe the most known IP right is trademarks. So a trademark protects a logo, a name. It can be the name of a company, the name of a product, but a trademark could also protect a color. For example, the famous red color of Louboutin shoes is protected by a trademark. And now you can even protect the sound with a trademark. And a trademark is something that distinguishes your company or your product or from others. Then another intellectual property right is the copyright. So the copyright protects a work of art, such as a book, a painting, a sculpture, for example, but it also protects the software, the code. It also protects databases, a software interface. And for copyright, you don't have to register it. It's granted as soon as you create the work of art. The copyright is granted to you. Something important about copyrights is you have two portions of the copyright. You have the commercial rights and the moral rights. The commercial rights can be sold, can be seized to someone. For example, if you hire an external programmer, the code that he will create for you via the contract you sign with him should be, so the commercial rights will be granted to you. But there are also the moral rights, and the moral rights cannot be seized. They cannot be sold to someone. So it's important, if you work with an external designer, programmer, whatever, that that person waives its moral rights. And I can just take one example. During the 70s, a big Canadian bank, a large one, hired the first designer to design its logo. And at the beginning of 2001, that bank decided to change, to modernize their logo. And they hired a second designer to modify the first logo that was created in the 70s. And they changed the logo throughout Canada. But the first designer never waived his moral rights. So the bank was not allowed to modify his work of art, so the logo he designed, without his consent. So the designer went back to see the bank, saying, you are not allowed to modify my work because I never waived my moral rights. And it has been settled with a check of a few $1 million. So it's really important that for copyright, if you work with external designers, programmers, that you ensure that they will waive their moral rights. And then trade secrets. So trade secrets is a piece of know-how, a piece of knowledge that you decide to keep secret. For example, the Coca-Cola formula. But to keep it secret, you have to ensure that you put mechanisms in place so that it will remain secret. So with that short introduction to IP, now we will talk about industrial designs.
Yeah. Thank you, Johan. That was a fantastic introduction to the intellectual property. Along with the trademarks, trade secrets, copyrights, there are like two more fields where you can protect your intellectual invention, or you can protect your creativity. We'll talk about industrial design here. The industrial design, it basically protects the aesthetic design of a functional item. It may not protect the functionality itself, but just the design part. It's more related to aesthetic. Just to give you an example, I have this bottle that I really like it. It has some ridges and here and some recesses at the bottom of this bottle. So I can file an industrial design for this bottle that will include, or that will illustrate, these ridges at the bottom of the bottle, and without mentioning what's the function or what's the functionality of these ridges. That's more design specific. It's more related to aesthetic or ornamental protection that we cover usually in industrial design. So we can say that it protects the appearance of a product, and it needs to be, the industrial design, it needs to be protected per country. For example, if you have file an industrial design in Canada, it is not protected in US or Europe, in any country in Europe or in any country in Asia. To have that particular protection in other countries, you have to file the industrial design in those countries as well. So you need to know where you're planning to have your business. If your business is limited to Canada, then there is no point of filing it in other countries. But if you're at the same time, to have it protected in your own country, it will give you the benefits that will help you to protect that particular design, but not the functionality. And it's not necessarily that this industrial design is always examined. And depending upon different jurisdictions, different countries, the duration of this industrial design could vary from 10 years to 25 years. That means you can have the protection for, you cannot have a lifetime protection for an industrial design. There is a tenure of the protection that varies between 10 years to 25 years. So that's about industrial design. And now another type of intellectual property is patents. Patents, I'm pretty sure you might have heard about this term patent, but what's a patent? What it protects, how it protects, and it's really subjective. And basically, patent it may protect a product, a process, a manufacture, or a composition of a composition, just like. We'll talk about some examples of what can be protected and what cannot be protected down the slides. But just like industrial design, to get your invention protected, you need to file patent in different countries. If you want protection in Canada, if you think that you have business in Canada, you file it in Canada. If you think that you have the budget to file around the globe and in different countries, you file in different countries to have protection in those countries. And merely filing a patent application does not grant you the right. You need to get that application examined by the examiner of that patent office. And just like industrial design, the patent also has a lifespan, and normally it's of 20 years. And now we'll talk more about patents. So what's a patent? It's basically, before talking about the rights and all that stuff, let's talk about what is a patent. So I'm pretty sure that you guys are well aware of your research papers, and you might have filed a few research papers, or you will be filing some research papers. So the research paper has a structure where you have a title, you have an abstract, you have some description, you have some figures, you have results, you have conclusions. So there are like different placeholders where you fill in some information. Similar to that, patent also has a structure. It has a name, it has a title, it has some background information, it has some summary, some description of figure, or it has a detailed description, and it has claims, it has abstract. So like it's also structural, that it also has a structure that in a manner that you draft a patent application. It's so when we say that claims and description, there are two different things. Whatever is in the claim, it is protected. Whatever it's in the description may or may not be protected. So just to give you an example, I'll use this bottle again. In the description, I describe this bottle and this cap separately, but in the claims, I do not claim this cap at all. So my protection will be limited to this bottle and not to this cap, even though I have described this cap in the description. But unless until I'll claim that specifically in my claim language, so this cap is not protected. So we need to be careful that whether this cap is a part of the invention or it is just some prior art. So coming to this question that you can see on the screen, what's a patent? So the patent is basically a right to exclude others from making, selling, or practicing an invention for a period of over 20 years. So it's, if I have a patent for a particular invention, I can stop others from using it unless until they'll come to me and ask for license, or basically they're asking for permission, and that permission could be in the form of license, it could be form of an agreement, or any sort of contract that the seller wants, that the seller can have with the applicant. If a seller is selling something and I have a patent about that something, I can proceed with suing that seller with for infringement. I can allege that the seller is infringing on my patent, and I can have my legal rights in place. There are legal rights in place that I can proceed to courts, or there are different measures that we can follow. The most important thing to note here, it's even though a patent will grant you right to exclude others from making and selling, there is also a right of exclusion. The inventor, in various scenarios, the inventor may not be allowed to practice his own invention. It might come as a shock to you, but it's true. Basically, just like your research, how you research, you see what's there in the prior art, you modify or you update the prior art, or there is some improvement on the prior art. And same thing happens with the patents. Most of the time the patents are improvement over the existing technology. So we'll talk more about this right of exclusion later in the slides. But even though you're an inventor, there might be certain scenarios where you might not be allowed to practice your own invention. We're saying this term a lot: invention. What's an invention? Invention, it could be any new or useful art, a process, a manufacture, or composition of matter, or any new useful information in the art. Basically, you identify a problem, you provide a solution to that problem, is an invention. But there are few exceptions to the invention. For example, you have a scientific principle. You have, like, for example, just Fourier transformation. Mr. Fourier developed this very beautiful transformation where he described that any time series or any time signal can be converted into a frequency domain signal. But it's a scientific principle. You cannot get a patent on a scientific principle, and you cannot get a patent on a surgery or a medical treatment methods, except in US. In US, you can have that sort of protection, but not in Canada. You cannot protect higher life forms. For example, animals, plants, mushrooms, fertilized eggs, some sort of higher life forms. You cannot get patent protection for those. You cannot protect energy forms. For example, you cannot claim some sort of energy, the transformation of energy. You cannot claim that. You cannot claim business methods. So there are like a list of exceptions that you cannot claim, even though they could be beautiful ideas, but they cannot be protected under patents. So you develop something and you wanted to file a patent application for that, and you want that patent application to be granted. Merely filing a patent application will not guarantee you that your patent application will be allowed. There are different criteria that need to be fulfilled before a patent application is granted, and those criteria are generally being categorized as novelty, non-obviousness, and utility. When we say that novelty, this novelty means that your idea, even though you believe that you're the first person who has developed that idea, you had developed that invention, and you try to file that with some patent office. But in some other part of the world, in some other corner of the world, another person with a similar thought process as you're having has already developed that stuff, or he has published, at least, even if he has not developed the product or something, he has published an article that, okay, this is how we could solve this particular problem, and this would be the product or process or method. And if there is a public disclosure of your invention, then you might not get a patent for that because it's not novel, even though there are chances that you develop that invention without knowing about the prior art, but that prior art still exists. So that's novelty. Your invention should not have been disclosed publicly, and not by yourself either. Like it's for example, you have uh, you have a conference, and you go to a conference, and you have this written conference paper. You give a presentation on that your invention, and that's counted as a public disclosure, even though you're the author of that conference paper, but still that's a public disclosure. So there's a limit. There is a time limit in certain countries. Various countries, they don't allow a public disclosure even by yourself. You cannot disclose your invention to the public and then you file a patent. It could jeopardize your invention, and it could affect your it could affect getting your patent granted. In countries like US, Canada, Australia, we have 1 year of grace period. It means that for example, there's a conference on 1st of January 2024, and you went to the conference. It was important for you. Your university asked for that conference, and it was required for you to present that paper. But once you did, you have 1 year from that date, from 1st January 2024 to 1st December or 1st January of 2025 to file a patent application within that 1 year. But that's only allowed in few countries, for example, US, Canada, and Australia, whereas there are many other countries where they don't allow public disclosure at all. And then there are a few countries, they have this time limit of 6 months, but they have like more strict requirement that they'll provide you a list of the conferences that if you have the disclosure in these conferences, then only you can file a patent application within the 6 months. So you really need to be very careful about the public disclosure. It's something that needs to be keep in mind, that if this is inventive, whether it's first of all, you need to identify whether it's worth getting a patent, and if it is worth getting a patent, then you should not be disclosing that invention to someone else's. And novelty, it means that it's from examination point of view, what will you do is once you have filed a patent application, and in various countries you need to file a formal request for the examination. You file the examination, the examiner will read your patent application, and the examiner will conduct a prior art search. He'll look into different databases to find if there is a prior art which is related to the claim. I'm specifically saying that the claim and not the description. It reads on the claims of a patent, and if the examiner finds that, okay, yeah, there is a suitable prior art, there is one single reference which is disclosing the invention in a similar manner as it is claimed, then we have the issues with the novelty. And now and then the second criteria is non-obviousness. Your invention needs to be non-obvious, and it should consist mainly in determining whether a person with ordinary general knowledge or ordinary skill in the art could be consulting the prior art. By consulting the prior art, could arrive directly with or without great difficulty to the invention, even though, for example, there is a public disclosure, or there is some prior art which may not discloses the invention as you have invented, but it's obvious to a person skilled in the art that this invention, I could develop this invention based on the knowledge that I have. So even though it's not disclosed in its entirety, but it is obvious to a person skilled in the art, then that could also jeopardize the patentability of your patent. Just to give you an example, on right side, I have two glasses. One, it's some sort of wine glass, and second, it's a cup. And your invention is on the right side, where we say that this glass has a handle to hold the glass. So in this case, even though it's novel, it's no single prior art teaches that a wine glass has a handle to hold this glass. But at the same time, you have the prior art where you have a wine glass and you have a cup, and you by combining the two, you can reach to the conclusion that, okay, yeah, my wine glass can has a handle. So that's non-obviousness. We'll talk more about patentability and infringement, and my friend, my colleague, my boss Johan will take over from here and discuss more about patentability versus the infringement.
Thank you, Mohit. So if there are two things I would like you to remember, the first one would be the concept of novelty, that if you publicly disclose an invention, it's no longer patentable, with a few exceptions, like the US, Canada, and Australia, where you still have 1 year to file a patent application. And the second thing that is important is that one, the difference between patentability and infringement. It's not because you are patentable, it's not because you have patents that you will never infringe on third parties' patents. It's very important because I met so many people during my career who say, oh, I'll never be sued for patent infringement because I have patents. No, it's not true. For example, you can obtain a patent for an improvement of an already existing technology. Because your improvement is novel, non-obvious, you have a patent granted. But what happens if the already existing technology was already patented by someone else? There's a risk. There's a risk that the improvement reads on the first patent. So basically, when it comes to infringement, for each client I meet, I always say your chances of infringing no patents is basically zero. And I just want one very simple example. So here we have Mohit. Come here. Yeah. Mohit is smart. He invented the wheel. He's lucky. He won the lottery. He had enough money to file a patent application in each and every country in the world for the wheel. So basically, Mohit is the only one who can sell wheels on Earth. I love his invention, and I invite a bicycle. The bicycle comprises 2 wheels. Because it's new, because it's not obvious, I can have a patent granted for the bicycle. But can I commercialize my bicycle? I can, but Mohit has a patent on the wheel, and my product comprises 2 wheels. So my bicycle infringes on Mohit's patent. So before developing a new idea or new product, you should be proactive and search for existing patents to ensure that your product will not infringe on third parties' patents. Now, how to avoid infringement? Well, you can do what we call a freedom to operate. So basically, we search into patent databases to try to find patents that could be problematic. So patents that would cover parts of your product. Once we have found those patents, what we can do is you can go try to get a license from the owner of the patents that are problematic, or we can design around the patent. So can we try to find a way to avoid what is protected by the patents. So that's the reason why it's important that that search should be done at the beginning of a new project. And also, to avoid infringement, you can copy an expired patent because, as Moit said, a patent lasts 20 years. So after 20 years, the patent expires and you can copy an expired patent. Also, to avoid infringement, you can buy the product directly from the owner of the patent. For example, in the case where I would sell my bicycle, if I buy the wheels from Moit, I cannot infringe on his patents because by buying the product from the owner of the patent, I have an implicit license of all of the patents that cover the product I bought. Or I could turn to Moit and negotiate a license so that I could be able to sell my bicycle. And finally, there are some insurances that you could get that in the case where you get sued for patent infringement, the insurance would cover the cost for the suit. And just to get an idea of how much patent litigation costs in the US, it's most probably at least $5 million US. So if one day you start a company or you work for a company, I think that you should always take a look at patent infringement because it can be very expensive. Now, for a company, why would you spend money on patents? If you do some R&D and you do not protect your inventions, your competitors will be able to copy you. By filing patent applications and protecting your inventions, you will force your competitors will not be allowed to copy you. So you will force them to spend money on R&D. So they will have to sell their products for more money. You could make some revenues from patents by selling licenses of your patents. Obviously, if you have patents, you can block your competitors, you can sue them, but as I said, it's very expensive. So really the main reason why I see for a company to invest in patents, it's because it will generate value for the company. And for that, you should know what is your patent ecosystem. So your competitors, your potential acquirers, your partners, do they have patents? If not, maybe it's not that good idea to spend money on patents. But if all of your competitors have patents, you don't want to be at risk because they have weapons. They can attack you, they can sue you. But if you have no weapons, if you have no patents, you will not be able to attack them in return. But most importantly, potential acquirers. If you start a company and you go for VC money, there will be an exit. The exit could be an IPO, but generally, the exit is the sale of the company to a bigger company, your potential acquirers. And if you realize that your potential acquirers all have patents and large patent portfolios, it means that they see a lot of value in patents. And if you do not protect your technology, you will be less attractive to them. And on the other hand, if you have invested in patents, they will see value in that, and you will be able to sell your company for much more. So as we said earlier, if you publicly disclose your invention, it's no longer patentable, except for US, Canada, Australia. So a good idea is always to have a non-disclosure agreement signed before talking about your invention. Another tip, when you have three inventions, basically you only have three choices. Either you can publicly disclose the invention. By doing that, your invention will become public and no one else will be able to patent it. You will not be able to patent it, but your competitors will not be able to patent it, which means that if you have an invention that is not really important and you want to ensure that you will be able to make it, that nobody will never sue you for patent infringement for that, publicly disclosing that invention that is not important is a good idea. The second choice you have is to keep your invention secret. First, can you keep it secret? Let's say it's some software that runs in the backend. So yes, you can keep it secret. But the problem with that is if you keep it secret and someone else invents the exact same invention as yours, apply for a patent application and then have obtain a patent, a granted patent, that person could sue you for patent infringement. And the last choice is when you have an invention is to file a patent application to protect it. But in that case, your patent application will be published. So your competitors will be able to know what you do and how you do it. I always say to my clients that what is patentable is not what you do, but how you do it. And in a patent application, the how, you have to describe it. So your competitors will know exactly how to reproduce your inventions. So yes, you can file a patent application to have a patent granted, but everyone will know what you do and how you do it. Another tip, so to be able to protect the IP, not just patents, general IP in a company, in the employment contracts, you should ensure that there are clauses that says that the employee assign all of his rights to the company. And it's the same with subcontractors, consultants. In the service agreement that you will sign with them, you should ensure that your consultant or your subcontractor assigns all of his rights to the company. Open source. So I'm pretty sure that everyone heard about open source. Open source is not free of rights. You have to be careful to the license that is associated with a piece of open source, the open source library that you would like to use. There are some kind of open source like GPL, for example. In the license, it says that if you use a GPL library, you must give back all of your codes to the community, which means that, let's say you have thousands and thousands of lines of codes that you have developed, but you are just using one library that is GPL, and you are obliged to give back all of your code to the community, which can be a disaster, really. I remember that once we were approached by a company, there were only one owner of the company. We were about to sell the company for 80 million. And during the due diligence, we asked that question: do you use open source? Yes. What kind of license? They didn't know. We went to see, and it was GPL, which means that the company was about to be sold for its technology, but the technology must have been given back to the community. and the value of the company passed from $80 million to zero. The company was never sold. And finally, to avoid any problems regarding patent infringement, because in the US, if you are sued for patent infringement and you were aware of the existence of the patent before getting sued, you can face what we call treble damages. Let's say you are sued for patent infringement in the US, you lost. You have to pay $100 million damages. But because you were aware of the existence of the patent, you can face treble damages, which is 3 times the damages that was given to the owner of the patent, which means that the damages passes from 100 million to 400 million. So it's really important that when you talk about third parties patents of your competitors, nothing written. There's some good news, the phone still exists. You can do a video conference, but nothing, no emails, no memo, nothing about that. And if really you have to put something in writing, put it in an email addressed to your lawyer and CC the person who you want to talk to. But your lawyer should be in the loop. And this is about it, I think. So we are ready for answering questions.